How many people in this room have been part of an arbitration proceeding? Anybody? You're a lawyer, you don't count. You can't. No, nobody's been a part. How about a court proceeding? Anybody been a part of a court proceeding? There's several of those. Lay people don't like to be parts of court proceedings. My guess is they similarly don't like to be part of arbitration proceedings. But let me ask another question. How many of you or your companies are a party to any agreement that requires arbitration to resolve any disputes? How many hands we have? I see about 3 or 4 hands out there. How about personally? How many agreements do you think you personally have that you entered into that require some form of arbitration to resolve a dispute? There's a couple people who know that. A lot of people have credit card agreements. You may have a binding arbitration clause in that. How many of you have property insurance, either on business property or homeowners policy? You probably have what's called an appraisal clause in there that says if there's damage to your building and you and the insurance company can't figure out what the amount is, you have to go to what is in effect binding arbitration. They call it appraisal in the policies. There are a variety of settings where arbitration agreements come up and you don't even realize it, that you are a party to one. And so hopefully today we can give you some information about what may be some of the pros and cons of being in an arbitration and having an arbitration agreement, so that when you are actually conscious that you're signing an agreement or looking at an agreement that has an arbitration clause in it, you can say, well, wait a minute, is this something I really want to do? Do I want to be part of arbitration here, or don't I if I have a choice? Another area that arbitration is very common is how many people have bought a house, personal residence. Standard form realtor's agreement has a box to check. If you have any disputes with the seller or the buyer, do you want to arbitrate them or not? And if both parties say yes, and there's a dispute, you're off to arbitration. So the issue comes up all of the time. So as a general feeling I have about arbitration is that it can be a faster and less expensive way to resolve disputes when the amounts involved are not a lot of money for smaller disputes. And because they don't allow all this discovery that happens in court proceedings sometimes. There aren't a bunch of depositions and all this pretrial things, not all these motions. You just exchange some documents, a witness list. 2 or 3 months later, you go before the arbitrator, you tell them your story, and you move on. That's kind of your ideal of arbitration, and you get some arbitrator who hopefully understands the issues, understands the industry, and you get some type of rational decision. That's what everybody hopes for when they go into arbitration. And my experience would be for smaller amounts that are in dispute, that can work and be a good way to resolve disputes. But if you get a lot of money at stake, arbitration is no cheaper than litigation. We've had, and Tim was involved in a couple years ago, a case that involved a lot of money over some intellectual property. And we were flying to the East Coast to take depositions. We flew to the West Coast to take depositions, multi-day hearings, very expensive arbitrator who was a retired federal judge. Everybody in that arbitration said there's a lot of money at stake. We're going to spend a lot of money either defending ourselves or pursuing our claims. And they spent it. And so the idea of arbitration is cheaper when it comes to large amounts of money. Arbitrators will typically allow parties to spend a lot if there's plenty at stake, and they can allow the same types of things to happen in the way of discovery and motions and depositions that happen in court proceedings. So don't just think I've got an arbitration clause that's going to be cheap, efficient, small. It doesn't necessarily work that way. Okay, why would you want to be in court as opposed to an arbitration? Well, most times, particularly if you're a defendant, somebody is making a claim against you, you want to have some protections that say they can't just walk in and grab my bank account or whatever they want. And court rules and procedures provide a lot of protections for parties called due process. There can be a lot of discovery. There can be motions that you can make before the judge before there's ever a trial that says throw the claim out or decide all or part of the issues. You ultimately get a hearing before, if you get to a trial before a judge and or a jury, you're going to get written out findings that say why you either win or lose or whatever, that explain the rationale for it. If somebody doesn't like it, they can appeal. There's always a right of an appeal in a court proceeding. In Minnesota, we have an intermediate level court of appeals that will hear any case, and then the Supreme Court hears just a limited number of cases. They don't have to hear most cases. But so lots of procedural protections. You have a right, if you want, in court to have a jury trial for most cases that involve claims for money or damages. Maybe you want a jury, maybe you don't, but either party has a right to demand it if there's just money damages involved. Another right that's in court that may not be there in arbitration is class action rights. So class actions arise where, and they talked earlier about the Microsoft litigation, you took one Microsoft employee and said, you didn't pay me my 401k contribution for 5 years. Well, what's that going to be? You know, $20,000, $30,000 dispute. It's hard to litigate against Microsoft for $20,000 or $30,000. But you get 10,000 employees in the same situation, then you've got a class action, and that makes that so that can be brought. Now, and companies have figured that out, and actually you as your company may want to figure that out if you don't want to be subject to a class action, because what some companies are doing is they're putting in arbitration clauses into things where if there's any dispute, it can only be resolved through arbitration, and then they don't allow class actions in arbitration. So there's a way to use an arbitration clause in a contract that can potentially insulate a company from being subject to a class action by the people who sign on to that particular contract, whether that's an employee, an independent contractor, whatever. So there's lots of protections in court, and you have to look at the flip side of what's there in arbitration. So, arbitration, very little. When you go to an arbitration hearing, the arbitrators are likely to listen to somebody testify to almost anything. We call it slopping in the evidence. Anything gets slopped in an arbitration hearing. In a court proceeding, supposedly there are rules of evidence that take out unreliable things, hearsay testimony. I heard that person say that to, something to that other person, and therefore it must be true. Hearsay type things. There's lots of evidentiary rules. In arbitration, that tends to get thrown out the window. If anybody wants to say something, the arbitrators are going to listen to it. Whether they believe it or not is another question, but it gets slopped in. Once there is a decision in arbitration by an arbitrator, it's extremely difficult to ever get that decision changed by a court. You can go to court and say, I want you to vacate this arbitration award, but you can't say, because they totally blew the law. They misinterpreted the law. It's completely wrong. This arbitrator blew it. The court has to say, tough luck. You agreed to arbitration, and if they blow it on the law or believe somebody you didn't want them to, tough luck, because Was there fraud or corruption by the arbitrator in the proceeding? No, they just made a mistake. And there's just very limited grounds to get it appealed. So you will see very few court decisions that overturn arbitration. The problem becomes I get more concerned about that when I have a defendant, because if there's a large arbitration award against a defendant, you'd really rather be in court because you have more grounds to appeal a court decision, more procedural protections. Just a few other things on the few safeguards in arbitration. In court proceedings, we see, particularly, in Minnesota with an intermediate level court of appeals, it is not uncommon for the Minnesota Court of Appeals to reverse a trial court decision. It happens with fair regularity. Certainly the reversal rate is well less than 50%, but it happens, and you can feel like you've got a chance if you've got a good legal issue to raise on appeal. And again, it happens, whereas if you're sitting on an arbitration award, the likelihood of you being able to say that I really have a good chance of going to, first of all, a district court, and then if I lose there, to an appellate court and get it reversed, it's just very slim. But I have a case later on we're going to talk about where that has happened. Another consideration for arbitration is this issue of a jury trial. And I think it's worthwhile, if you think about it, when you're going to sign an agreement that says arbitration, is if I have a dispute, would I like to have this dispute decided by a jury or arbitrators? And that can be very different. There are many times, particularly businesses, companies, that don't want their disputes decided by juries. Example, if your business does any has a loan with a bank, the likelihood is those loan documents have in big bold print someplace that you, the borrower, irrevocably waive your right to a jury trial. Banks don't like to go to court and be subject to what a jury might say. So that can be in your agreement. But if your agreement simply says, I agree to binding arbitration, it's not going to say anything about a jury trial, but in effect, you are waiving a right to a jury trial because you can't get a jury in arbitration. You're going to get an arbitrator or a panel of arbitrators. So you have to think, as you're looking at a contract, is this something that my company as a party would rather have a jury look at if there's a dispute, or would we rather have whoever would be the arbitrators look at it? And I think it's worthwhile. And the difference is, you go to Hennepin County District Court and you get a panel of jurors impaneled, and I will guarantee you that panel will look nothing like the faces I see out here. It's not going to be your peers. It's going to be multicultural. It's going to be younger. There's going to be a lot of diversity in that panel, and they can have a lot of common sense, but it's not going to be the people that are in this room, or if there are the people in this room, there's going to be one or two of them that look like the people in this room, and not the whole panel. So you have to give some thought about who you want it. Arbitrators, on the other hand, all the times I've had it, I'd say the youngest arbitrator I've seen in any arbitration has been in their 50s, and a lot of them are in their 70s. Those people have a different perspective on life than your 6-person civil jury, probably maybe 7 or 8 in Hennepin County or whatever. They have a different perspective, and so you have to think a little bit if you want, what type of person do you want deciding this type of thing? Because they're very different, and the biases that each of those different groups bring to it may be the most important thing in ultimately what the outcome would be. Example. In the last couple of years, I've had 2 arbitrations that have in my career that have lasted about a week, that have had multiple expert witnesses, claims of over $1 million involved in them, and the most recent one was over a real estate transaction, and the plaintiff had bought real estate from my client, a house, and they both had realtors involved, and they checked the arbitration boxes, so we were into arbitration. Well, the plaintiff was a very nice looking young couple with a young baby, and they didn't go to arbitration. They started a lawsuit in district court and said, we want to sue, and we're claiming $1 million of damages. And we looked at that and said, you know, this is a very nice young couple. They look nice. We think their claims are crazy. Would we rather have them go sit in front of a jury, or would we rather have them sit in front of some gray-haired old arbitrators? So we said, we'd like the latter. We don't want the former. So we made a motion to what's called motion to compel arbitration, saying, wait a minute, you signed an arbitration agreement, you can't sue us in court. And that motion got granted. And so we ended up in arbitration. Arbitration lasted for 4 full days, multiple expert witnesses. But one thing that we did in that arbitration, because a lot of times there's an election, you can have one arbitrator, or sometimes they'll provide, and in this case the rules provided, if the dispute exceeds a certain amount, you can request 3 arbitrators. Now you have to pay them all, and the parties have to divide the costs, but you're looking at the case and you're saying, okay, do I want 1 arbitrator for this plaintiff that's claiming over $1 million, or do I want 3? And the analysis is pretty simple. It's easier to fool 1 person than it is to fool 3 people. I want 3 arbitrators. So that's a protection you have, that at least you've got 3 people looking at it, and then if one goes off the track, you got a chance at keeping the other 2 on the track. So that's a way of looking at these arbitration cases and when you handle them, what you want to do. Yeah. So arbitration agreements and employment agreements, it's very common. And although that where in employment agreements that there are arbitration clauses that say if there's a dispute, we'll submit it to binding arbitration. Or even if there's not an arbitration clause, there will be a clause that says, we say the law of Minnesota or the law of California, whatever state has some connection, we want that law to apply, and they'll pick out any dispute. If it goes to arbitration or court, it should be in Minnesota, or it should be in California, or wherever the place is. So those kind of things are very common in employment agreements and can be placed in independent contractor agreements. But the place of hearing, in my judgment, is critical. And it's critical because if you sign an arbitration agreement that says you're agreeing to arbitrate, and that's going to be in some far-off location from where your business is, then you have a lot of risk. What is the likelihood of you traveling out of town, if you want to be the claimant, and having to go to a hearing in some far-off city? I mean, there's airplanes, you can get there and all that, but you're not going to know. You're not going to know who any of the arbitrators are. You don't have any connections to that city or that location. What's the likelihood of you going there and successfully presenting a case if you want to get some money from somebody? So if you're going to be the claimant or the plaintiff, you think, under that agreement, you have to be very careful. Similarly, even if you're going to be a defendant, you want to be a defendant where somebody's claiming a bunch of money against you in a far-off location where you have no connections, where your other party that you're entering into a contract may have lots of them because they do business there, but you really don't. So those kind of clauses in agreements are critical, and it comes up many times in the context when you're selling a business. Let's say there's an out-of-state buyer of a business, and they come in and say, we're from Florida, and if we have any dispute over this contract to sale, we want it to be arbitrated in Florida. And you say, well, maybe you're Minnesota, you can agree to that, but I want you to know the likelihood of your ever pursuing a claim in Florida or being successful is materially reduced if you want to agree to that. You should argue and say that's going to be in Minnesota, because you're going to be much more likely to either defend your rights, protect your rights, and I think potentially more successful if you're in your home state than if you're in an out-of-state location. I'm not saying litigation can't be won out of state. It can, but it's more difficult. It's really key what law applies. Many times arbitration agreements, but even independent contractor agreements that don't call for arbitration will talk about what law applies, what state law applies. And it's important in Minnesota for non-competition clauses in employment agreements. And it's not uncommon that there'll be a 1 and maybe a 2-year period of non-competition for some geographic area as to some type of products or activities that you as an employee or as an employer want to have enforced. And so if you sign an agreement in Minnesota that says an employee will not compete in this sales area in the geographic area you do business, which is 7 states, for 1 year after they terminate their employment, and that will be governed by Minnesota law, the likelihood is a Minnesota court will enforce that if it has all the other elements. But if you go to California and sign that same agreement, California's law says, no, we don't like non-compete agreements. So where does that come into play? What if you're hiring somebody who's got an employment agreement with a non-competition clause that was done in California, or was done in Wisconsin, or was done in Florida, and it's governed by that law? You know, you have to decide, wait a minute, this employee I'm planning on hiring, they've got this former employer that has this. How does that apply here? Do I want to take a risk? Are we going to be interfering with that? So anyway, same issues with regard, then you have issues with regard to trade secrets, where employees misappropriate trade secrets or take confidential or protected information. And I'm going to move on because I've got our case that's going on that I want to talk about. Seagate Technology versus Western Digital. This Minnesota Court of Appeals decision from this summer. They talked about how much at the Microsoft trial was it? 97. This is a $640 million case that got decided in arbitration. $640 million. It is an arbitration decision. Arbitration went well, what happened? Arbitrator, former employee of Western Digital, gets hired by Seagate, allegedly takes some trade secrets with them and, you know, digital information downloads. The arbitrator in the case is a retired judge. The proceeding goes on for over 4.5 years, 100 pretrial rulings. The hearing went over 34 days. Now, does that tell you arbitration is cheap? I mean, this is eyes open. Turns out that the employee, they decided, destroyed or fabricated some evidence, and the arbitrator found that Western Digital, his new employer, was complicit in that. And because they tampered with the evidence, the arbitrator said, I'm going to sanction you, and on 3 out of 6 trade secrets that they say were stolen, Western, you can't put in any evidence on those 3 because you were complicit in helping this employee tamper with evidence. Now, can an arbitrator do that or not? Well, they awarded over 600 million, so it got appealed to the state district court. Hennepin County District Judge says arbitrators can't do that. They don't have authority to do that. Minnesota Court of Appeals said, yeah, they do. So now the case is on appeal. Minnesota Supreme Court, I assume the number got their attention. Not only the companies are major companies, but with that kind of money at stake, the Minnesota Supreme Court has decided to hear this case to decide if an arbitrator can sanction somebody for this and let that award stand. So there's your war story for if you look at an arbitration clause and say, hey, this is going to be a cheap, simple way to resolve my dispute. Not necessarily. This is an employment case. And it tells you also if you're hiring employees who have non-competes, non-solicitations, who have any trade secret or confidential information of their former employer, you don't want to get involved with that. It doesn't pay. It didn't, at this point, it's cost, Western Digital's got that liability on its books. We'll see what the Minnesota Supreme Court does with it next year.
Keith, quick question.
Yeah.
On that case, why did they end up in arbitration?
Well, I can't quite, the employee had an arbitration clause in his contract with Seagate. And what I'm not able to figure out from the decision is how Western Digital got hooked in, because it doesn't say that. It just quotes the arbitration clause that the employee had. But I assume that Western Digital made a decision to say, listen, we'll participate in the arbitration too, because generally, if you don't have a signed arbitration agreement with somebody, you can't force them to arbitrate. We have an arbitration going on right now on where somebody has named as a defendant in arbitration somebody who didn't sign the arbitration agreement. One that did and one that didn't. And we're saying to the arbitrator, you can't arbitrate as to that one person, beyond the scope. We should win that argument, but haven't had a chance to present it to the arbitrator yet. So I assume Western Digital must have agreed to it.
So on the appeal aspect of it, is it just as regard the appeal rights?
Well, I've oversimplified it here. There's lots of arguments when there's 600 million at stake. So I'm oversimplifying the case on these slides. But a major issue in the case is whether an arbitrator has the authority to issue that sanction because of this tampering with evidence and exclude evidence on 3 issues, and then boom, you have this big damage award. And the big damage number alone will generate an appeal. But it's a fascinating case to watch. So anyway, there's other places where you find arbitration clauses. I've got some things, and I'm out of time, so let me just make a couple of comments. It's in the materials about considerations when you're signing an agreement. Should I arbitrate or not? And I think question number 1, do you think it'll really be faster and cheaper? And are you concerned about there being procedural safeguards? And the number 2 thing is think about who's going to be the decider of this dispute. Would you rather be in a position where that jury, cross-section of the community, is deciding a lot of issues? Or would you prefer to have what are likely to be gray-haired older people decide it? Big thing. And then I have a number of other things to look at that's in the materials, but I'm out of time. I guess I can take a question, or maybe I can't. I don't know. If you have questions, I'll be here afterwards.